The session title is What are the implications of withdrawing from the ECJ? And we've seen this question over pulling out of the jurisdiction of the Court of Justice of the European Union, or the ECJ sometimes, many times over the last year or so. I will personally admit, you'll hear this, I'm not from the UK. I'm also not, as you will see in a second, not from the US. I'll admit that it is a question that's left me puzzled for a fairly long time, right? This idea we need to pull out from this institution, the ECJ, right? So you may ascribe that to me having grown up with European integration at my literal doorstep. I grew up next to the border to France, and if I look at the last 1,000 years of history, that particular border area, France, Alsace, Lorraine, Baden on the other side, on the German side, has not seen 70 years of peace over that time period. So I'm imbued with that, if you will, right? But more fundamentally, I think it's a question that epitomizes what I think is the somewhat inward-looking context of Brexit. But before we start, let me echo David Alan Green's recent FT column, and he said that any confident assertions about legal liability are likely to be more bluster and defiance, right? So take what we say with a little grain of salt, I think. But because some of the things that I think not only lawyers but also economists say are often overtaken by political considerations, right? Political expediency, short, long-term, mid-term, I leave that up to you, will sometimes overtake that. But what we'll do is the panel will look at the legal implications of Brexit, including the withdrawal from the Court of Justice of the European Union, but also beyond, by looking at the WTO and by looking at investment law. So one of the questions you could ask yourself is, do we need divorce lawyers for Brexit, or do we need public international lawyers / public lawyers? I can't provide you with a single divorce lawyer on the panel, but we have the next best lineup possible, namely 3 outstanding experts in EU and international law. And as we'll see, these areas are intertwined, right? So we have 3 areas that overlap here. National law on the one hand, EU law as a secondary, not secondary in terms of importance, diminishing or so, but a second layer of EU law, and then we have international law on top of that. And this multiplicity of rules makes this much more complicated than some may think, and you would be led to believe if you listened to the news or even read some official reports, may I say. So let me introduce our speakers now. On my right, to your left, is Catherine Barnard. She's a professor of EU law at Cambridge University and a senior fellow at the UK in a Changing Europe. To my immediate left is Takis Tridimas, who is a professor of European law and the director for the Center of European Law at King's College London. He also is a barrister with Matrix Chambers. All the way to my left, to your right, is Holger Hestermeier, who is a reader in international dispute resolution at King's College and a former referendaire in the European Court of Justice. And I think that's actually true for you as well, right? Did I read this right?
That's correct, yes.
That's correct.
Long time ago. Huh?
Long time ago, he says. Holger is also a specialist advisor to the House of Lords EU Foreign Affairs Subcommittee on its inquiries on trade with the EU post-Brexit. We have agreed, all the speakers have agreed, and I will hold them to that, to speak for no more than 15 minutes. I will use my German temperament and sort of cut people off at that point to put a stereotype out there. And Catherine, you'll start us off.
Thank you very much indeed. It's an honour and a privilege to be here. You kindly introduced me as Professor of EU Law. I tend to say I'm Professor of ex-EU Law. I'm also Professor of Employment Law, so at least I know what redundancy looks like, but we do have work for a short period of time ahead. Now, I'm going to talk a bit about what the situation is at the moment, and my very distinguished colleagues will talk about the alternatives. So, what are the implications of withdrawing? Now, as we know, withdrawal from the European Court of Justice is one of Theresa May's red lines, and we can see that in the white paper. This is a key component of taking back control. Court of Justice is the EU's ultimate arbiter on matters of EU law. As a supranational court, it aims to provide both consistent interpretation and enforcement of EU laws across all 28 member states, and a clear process for dispute resolution when disagreements arise. Now, I don't think I could have put that better myself. In that white paper, you've got a very clear statement of why you need a supranational body to enforce and uphold trade agreements. Now, the white paper goes on to say, and I suspect this is what the government and the Leavers are most concerned about, the CJU is amongst the most powerful of supranational courts because of the principles of supremacy or primacy, so EU law taking precedence over national law, and also direct effect, which is about the enforceability of EU law in national courts. And without so much explaining why one thing leads to another, we have a clear statement that we will bring an end to the jurisdiction of the Court of Justice in the EU. So this terrible monster of a court, is it as bad as it's been built up to be? Well, crudely speaking, the court does three things. First of all, it interprets what EU law means. An important role, because often EU law is badly drafted. Why? Because it's a product of compromise. And the way most of its interpretation is done is as a result of a case starting in a national court not knowing what an EU rule means, and then there is what's called an Article 267 reference to the Court of Justice to explain what this rather obscure might mean, and the case then comes back to the national court. Secondly, it's actually there as an enforcer of EU law. The Court of Justice is there so that when the Commission thinks that a member state is not complying with the rules of the game, the Court of Justice will be engaged under the Article 258 procedure, and the member state will be formally reprimanded. And if the member state still doesn't get its house in order, the case goes back to the court and the member state can be fined. So it's an important vehicle for ensuring that the rules of the game are actually complied with, which has always been in the UK's best interest, because generally we already comply with the rules of the game. So it's in our interest to make sure that the other sides do so as well. Third thing the court does is to rule on the validity of EU law. If EU law has been passed where the EU law there's no justification for it, there's no good explanation for it, there is no competence for the EU to act, the Court of Justice will consider that under Article 263 and will challenge it. So that just gives you in outline, actually, why the Court of Justice is important, and thus supports what the UK government said, that it is very important because it ensures both consistent interpretation through the Article 267 process and also the enforcement of EU law through the Article 258 process. As I say, the white paper is absolutely spot on. But that rather overlooks the practical realities. Court of Justice deals with about 1,700 cases a year, so a lot, but if you think about the fact you've got a population of 500 million across 28 member states, that is the tip of the iceberg. Most of the cases are dealt with either in the national courts, or people just comply with the law because they know that if they don't comply with the law, there will be the possibility of cases being brought in the national court. And this is what this diagram is very briefly to show. This is the language of direct effect, which is what lawyers use to say about the enforceability of EU rights. EU rights, so provisions in a directive, provisions in the treaty, are enforceable in national court. So if I've been discriminated against on the grounds of my sex, and EU law is more generous to me, I can challenge that discrimination in the local court here in London or in Cambridge, and I can enforce that right in the UK courts, either against the state, if the state happens to be my employer, or against a private sector employer. Nothing to do with the ECJ. ECJ is there as an ultimate fallback. At the moment, the shadow effect of the ECJ hangs over the proceedings, but basically there's a mechanism to get EC law enforced in the British courts. Jumping ahead to what my colleagues will say, all other systems which are being considered, none of them have this possibility of enforcement in the domestic court. There's no other system apart from the EU system with direct effect in the very full form that there exists in the EU system. And also there is no other vehicle of quite the kind which allows this engagement with the Court of Justice through Article 267. So I've given you a brief summary of what the Court of Justice does and how it operates both at EU level and at national level. So we're losing that. Does there need to be something in its place? Well, for the first time, to my knowledge, in a public document, the UK government has recognised that there needs to be something else. And indeed, it's a sort of backhand compliment to the ECJ that it's already done a pretty effective job, but so effective that it's trampled over the control of the British courts. And so in the white paper, there is a clear statement that there does need to be something which replaces the Court of Justice. We recognise that ensuring a fair and equitable implementation of our future relations with the EU requires provision for dispute resolution. Dispute resolution mechanisms ensure that all parties share a single understanding of the agreement. We need to have a referee to ensure that both sides uphold the bargain, both in terms of its interpretation and application, what the Court of Justice has been doing. And the mechanisms must also ensure uniform and fair enforcement of agreements. So, what are the alternatives? The white paper offers a couple, and my colleagues will go into them in much more detail, but I'm afraid I think the white paper is scant in terms of detail about the alternatives. Dare I say, it looks rather like someone has typed into Google, what else can we do, help? And up has come the New Zealand Korea Agreement, not the first one that would spring to mind, but also various others. And they have, of course, to be fair to the government, they would say it's merely examples. But I'm afraid on this issue, which we as lawyers think is crucial, and which I hope you as economists will appreciate is crucial, and if you don't already, you will be convinced by the time we've finished speaking, that there needs to be something, and there needs to be something effective. So they talk about CETA, the Canadian Free Trade Agreement, where you've got a joint committee which supervises the implementation and application of CETA. No, nothing judicial there. An ad hoc arbitration panel. Lawyers don't like anything with the word ad hoc in front of it because there's no build-up of expertise. And there are all sorts of issues about how you appoint that arbitration panel. And then, of course, there is special provision for investor dispute settlement. And you'll hear about some of the problems about that shortly. NAFTA, there is a nice, cosy, amicable settlement of disputes. That doesn't sound very robust to anyone who's a lawyer. It's really pretty thin. So what's interesting is the white paper goes on to say the actual form of dispute resolution in a future relationship will be a matter for negotiations, and we should not be constrained by precedent. I think that's important because I think that's sending out a signal that none of the previous models are any good at all, and there needs to be something else. And answers on a postcard, can we come up with something which works better? And I think that's what this is a call for. Can an imaginative solution which doesn't involve the ECJ be dreamt up, which might satisfy all the things that the ECJ currently does? They then talk about any arrangements must be the ones that respect UK sovereignty, protect the role of our courts, and maximise legal certainty, very important. And that brings me to this. This cartoon is one I really like because it was appeared just at the time of the Miller judgment. Miller, as you recall, was the judgment which basically forced the Parliament to consider whether Article 50 should be triggered, and it took British courts to say to the British government that the British Parliament needed to be involved in the Article 50 process. But this ambivalence to the role of the British courts, which are meant to be there as the main strand of taking back control, is indeed rather striking. But anyway, the message is clear that it will be the British courts eventually which will take back control and will decide how we govern our lives and how how laws will be applied to us. But just wait a moment. There will, whatever the White Paper says, be a residual role for the Court of Justice. And it would be disingenuous to suggest that the Court of Justice will, come the 31st of March 2019, have no influence on our judicial system. And there are a couple of ways how the Court of Justice will continue to affect our day-to-day lives. First of all the case law pre-Brexit will carry on being binding. We don't quite know what form that might take, but it will certainly carry on being binding as it is at the moment, and British courts are very used to applying European Court of Justice decisions and giving them precedential value, i.e. we follow what they say, and also probably a supremacy, because we're used to saying that what the Court of Justice says on the interpretation of EU law will bind British courts. Post-Brexit, it was thought that the decisions of the Court of Justice would be merely of persuasive authority. It would be interesting to take into account what the Court of Justice says on interpreting an EU provision. However, there's a problem. One, post-Brexit case law will not have the benefit of British judges deciding the cases and British advocates arguing the cases. The common law has had a disproportionate influence on the shape of the judgments of the Court of Justice since 1973. Yes, of course, Ireland will still be there, but the UK has certainly punched above its weight, or to be precise, England and Wales have punched above their weight in terms of influence in the Court of Justice. And furthermore, if you look at the White Paper reasonably closely, it suggests actually that these judgments might have more influence than we first thought. You'll see it says, in general, the government believes that the preserved law should continue to be interpreted in the same way as it is at the moment, thus suggesting that the case law will have as much significance post-Brexit as it does now. Furthermore, there are other areas which apparently we want to opt back into, the European arrest warrant being one, which the operation of which is dependent on rulings of the Court of Justice. Because it's important to think, and this is my last slide, it's important to realise that EU rights are premised on EU remedies, and by EU remedies I mean the decisions of the Court of Justice. And this is a point which is very difficult to get away from. Finally, for you, those of you who are interested in commercial matters, some areas of EU law have what's called extraterritorial effect. In other words, they apply outside the territory of the EU. Competition merger law is a good example. Google, Microsoft have felt the wrath of the European Commission, and they have challenged the decisions of the European Commission before the Court of Justice. If there's a hard Brexit, nevertheless, EU competition law will continue to apply extraterritorially and will affect British companies, and they will want to be able to challenge any decisions that are made against them before the Court of Justice. Furthermore, I gather you've been discussing this morning the question of financial services and what might replace passporting, and whether there are determinations of equivalence. What happens if equivalence is not determined? Is that merely a policy decision, or is it a decision which has legal effects which can be challenged under Article 263. We would clearly want to be able to do that, because clearly it will have significant financial costs. So my bottom line is, the Court of Justice ain't going away, whatever the UK government might say to the contrary. Thank you very much.
Thank you, Catherine, for this, what you consider an introduction, what I think is an in-depth look at the landscape before us. I have questions already, but I think we'll leave them for later. Takis, the floor is yours.
Thank you very much for having me. It's a great pleasure to be here and an honor. I thank the organizers for including me in this event. I was going to make some comments under three headings. First of all, outline the distinct features of the EU legal system, although Professor Barnard did that in a much better way than I would hope to do it. Say a few things about attributes of arbitration resolution systems in bilateral investment treaties, and then provide an overview of the kind of dispute resolution systems included in EU international agreements. The third one is part of a research project that I am currently undertaking. So the first point, and just complementing what Professor Barnard said, what is distinct about EU law? And I think there are two elements. One is this idea of direct effect, the ability of individuals to enforce EU rights before national courts. And secondly, the interjudicial dialogue. The EU law is integrated into national law, and through the preliminary reference procedure that Catherine mentioned, there is a dialogue between the national judiciary and the European Court of Justice. So the combination of direct effect on the one hand and the judicial conversation gives to European Union law an immediacy which is similar to that of national law. So in a nutshell, if one were to ask me what is distinct about EU law since the establishment of the European communities, I think what is distinct is that it abolished the monopoly of the nation state to grant rights. This is what EU law has done. It has separated itself from international law. This idea of giving rights to citizens is no longer the prerogative, the monopoly of state power, but it has become part of a supranational authority. And I think this is the distinct feature of EU law, which then leads to, if you wish, a hybrid system for judicial protection. It has some elements which are based on national law, some elements which are based on EU law. The two are integrated, leading to the hybridization of remedies, of enforcement of judicial protection. To put it in another way, some 25 years ago, Judge Mancini, a member of the European Court of Justice, encapsulated the distinct character of EU law by saying that this principle of direct effect, which is in itself a product of the case law of the European Court of Justice, took the law from the hands of the bureaucrats and gave it to the people. And I think what Brexit does is to reverse that process. I think what the government wants to do is to take the law from the hands of the people and give it back to diplomats, to bureaucrats, increase the discretion at governmental level, lower the remedial effect of EU law. So if we look at other international agreements, what kinds of dispute resolution mechanisms do they have? I'm only looking at so-called bilateral investment treaties, and outlining very briefly what the basic features are. I'm afraid I don't have any slides. I'm the only PowerPointless member of the panel. Bilateral investment treaties include essentially two kinds of arbitration mechanisms, of dispute resolution mechanisms. One is the so-called state-to-state arbitration, where one of the contracting parties can take the other contracting party to an arbitration tribunal. The other method of enforcement, which is quite usual in bilateral investment treaties, is the so-called investor-state arbitration, which enable a corporation from one of the contracting parties to sue the other contracting party, to sue another government, in other words, not before the courts of that government, but before an arbitration tribunal. So we have state-to-state arbitration and investor-to-state arbitration. The agreements tend to contain various limitations, limitations as regards who can bring proceedings before the arbitration tribunal, limitations as to the subject matter and the scope of jurisdiction, limitations as to the timing of jurisdiction. And also they do not tend to have any specific rules on procedure for under which the arbitration tribunal will work. Also, very few of these bilateral investment treaties contain any provision on interim measures. Interim relief, i.e. the relief that the party gets until final judgment is given, can be, for lawyers, for parties, very important in practice. So they differ from the European Court of Justice and the system that applies in EU law in a number of respects. The European Court of Justice is an international court. Arbitration panels are considered alternative dispute resolution mechanisms. The European Court of Justice is part of a constitutional system of multi-level governance, if you wish. Bilateral investment treaty tribunals are not parts of any such system. There are differences, very important difference in relation to access, who can access the court, in relation to the scope of jurisdiction of the judicial body, in relation to the process guarantees, the procedural guarantees that may exist, and also many differences in the relationship between the arbitration tribunal and the national judicial system. As I said, in the context of EU law, the EU judiciary and the national judiciary are integrated. Just a bit of road mapping. One can trace 110 bilateral investment treaties concluded by the United Kingdom between 1975 and 2010. Some of them are terminated or no longer in force. All these agreements are pretty narrow in their economic scope. Interestingly, they don't protect things like sustainable development or human rights. Those that protect labour standards have an EU element into them. So those that come from the UK tend to be heavily focused on economic matters. It appears that the United Kingdom has been involved in 58 investment disputes under those agreements. And in most of them it has been involved as a claimant, so it is the government that takes the other party to the court. There has been only one known case. The difficulty with these cases is that they are not necessarily reported, so we don't have a full picture. So there is only one case where the United Kingdom has been the respondent, has been the defendant, but the outcome of this case is not public. That gives you, of course, as Catherine said earlier, and as the white paper of the government provides, you are looking for something new, precedents, previous practice or previous models will not necessarily prove appropriate for what is to happen in relation to the dispute resolution system that will be contained in any future trading agreement with the EU. So in this relation, I suppose in this context, one could identify various options. There could be an agreement with the EU with no dispute resolution system at all. I think this is unlikely, and it is unlikely first because the government in the white paper states that it wishes to have one, and certainly the EU also would be in favor of that. The third point in the presentation, allow me to say a few words about a research project which I am carrying out. It's at an early stage, and what I'm saying is based heavily on my colleague's work, Georgia Sangiolo, who is present in the room, and she's carrying the research project with me and has done an enormous amount of work on this. What we are trying to do is this. We are trying to look at the international agreements, trade agreements concluded between the EU and third states, and try and map out what kind of dispute resolution systems exist in those agreements, and see how they have evolved, try and find if there are any patterns that we can distinguish with a view to informing ourselves about the conduct of the EU, the practice of the EU, how does the EU view dispute resolution procedures in its external relations, and also to see how that might perhaps play a role in any future agreement that the United Kingdom will conclude with the EU. We are looking at a total of 91 agreements concluded by the EU. The overwhelming majority of them do include a dispute resolution mechanism in the form of an arbitration, a quasi-judicial procedure. Very few of them, about 8 of them, only provide for a political mechanism. The basic trend, I think, is that there is a direct link between the remit, the breadth, and the complexity of the agreement on the one hand, and the sophistication of the dispute resolution mechanism on the other. The more areas the agreement covers, the more sophisticated, the more detailed that the dispute resolution mechanism is. So political agreements, agreements that have a framework nature, or purely sectoral agreements tend to have very brief provisions on dispute resolution mechanisms. By contrast, those agreements that provide for market access, that provide for trade liberalization, that provide for a degree of harmonization among the laws of the contracting parties tend to be backed up by sophisticated mechanisms. One aspect which I think is important to bear in mind is that the external trade conduct of the EU is conditioned by its commitment to advance its values and protect fundamental rights in the international plane. Article 21 of the Treaty on European Union states that when it pursues external relations, the EU has to promote the policies of democracy, the universality of human rights, the rule of law, and this has, we think, inhibited the European Union in the kind of partners with whom it might conclude international agreements. That, of course, would not have a bearing in relation to the United Kingdom, but I think it is important to bear in mind. So what sort of things are we looking at? Well, we are looking at the selection and composition of the arbitration tribunal, the number of arbitrators that may be required. Generally, the higher the number of arbitrators, the more independent the arbitration tribunal is considered to be, because it reduces the exposure factor. There is a collective body that takes the decision. We are looking at transparency. This is an important consideration. It is not to be taken for granted in arbitration tribunals, but if one identifies a trend over the years, is that there are increasingly transparency provisions, and by transparency I mean the obligation to make the ruling available or to make the ruling of the arbitration public, the obligation perhaps to make the hearings public, and so on and so forth. Another aspect that we are looking at is third-party participation. Who can appear before the tribunal, whose voice can be heard. This is important because the more comprehensive the agreement, the greater the range of interests which are being affected directly or indirectly, and therefore the greater the resonance, if you wish, and the impact of the agreement. So, in a nutshell, as I said earlier, what we are seeing is a trend towards greater judicialization of dispute resolution settlements in international agreements concluded by the EU. And of course, this is important. It is important for two reasons. First of all, because the greater the degree of judicialization, the greater the effectiveness of the reciprocal commitments undertaken by the parties. Secondly, the more the greater the degree of judicialization, the more the agreement and the decisions of the tribunal contribute in shaping the domestic system of governance. Just like the European Court of Justice has had an impact in the development of EU law, if you have arbitration tribunals which deliver rulings that are transparent, that they are bound by certain process, independence requirements, substantive requirements, the more it is likely to affect the development of the law of each of the contracting parties. Thank you very much.
Thank you so much, Takis. And Holger, the floor is yours. 50 minutes. And I'll start your presentation.
The great advantage of being the third to present is I can build on everything that was said before. Don't worry, there will not be a test. The disadvantage, of course, is that you've already heard from two lawyers, and I'm not sure you really want to hear from a third one, but I fear there's no way around that. Basically, I want to cover 3 points. I want to say, why are there dispute resolution mechanisms in trade agreements? I then want to explain the WTO system. Why the WTO system? Because that is the general standard model for all trade agreements that everyone departs from. And in fact, if you look at the reality of trade disputes are litigated in the WTO. They are hardly ever brought to regional or bilateral free trade agreements. I will not speak about investment disputes at all. And then finally, I will compare the EU and the WTO system using a practical example to drive the point home and to make this understandable, particularly to non-lawyers, and to make everyone feel at home. I will use Marmite, of course. Now, why do we even have dispute settlement arrangements in trade agreements? They are prevalent in almost all free trade agreements. In fact, the very few free trade agreements that don't have them tend to have one incredibly strong and one incredibly weak party. So you see where this is going. The resolution of the dispute is done by power relationships, but most have them. The WTO, Dispute Settlement Understanding, says the function is to provide security and predictability to trading systems. So you have an organ interpreting the law that is neutral and that does the job of interpreting. If it's a very advanced system, it will be an organ like the ECJ that can be somewhat more creative in its interpretation. If you look at the WTO, it's a very conservative interpreter. The early history of the WTO is basically the usage of the Oxford English Dictionary. Of all sources that they refer to, the Oxford English Dictionary to interpret the wording of the treaty was the most important one. to preserve the rights and obligations of the members. Because only if you have a neutral instance to go to can your rights be guaranteed. If you don't have that, then you can complain to the other party, and the other party will say, well, we think a clause that says don't raise tariffs is complied with if we raise tariffs. And there is nothing you can do about it, no matter how absurd the statement. And then dispute settlement clarifies the existing provisions. Now, of course, you might not be convinced by any of this. Lawyers inherently find the existence of courts a natural phenomenon. Non-lawyers, not naturally so. Then one more incentive why there will be a dispute settlement mechanism in any free trade agreement with the EU. The EU has told Switzerland in no uncertain terms, we will block all further agreement on developing our bilateral relationship without having an institutional structure. So there's a limit to how far you can go in integrating trade without an institutional structure, and part of the institutional structure is a court. Now, what does dispute settlement look like in the WTO? And if we were in a public international law environment, I would say the WTO dispute settlement mechanism is one of the strongest ever conceived. But of course, we will compare it to the European Court of Justice, and so this falls by the wayside. Now, first thing, who can go there? Who can complain about what? Only members have the right to use WTO dispute settlement, that is, members of the WTO, which, for our intents here, will be states. Only states. Companies cannot use WTO dispute settlement, and they can go there, and again, I simplify a little bit, for complaining about breaches of WTO law. So basically, of trade law. And if you look at a trade agreement, you will see the provisions can be very broad. The WTO, for example, does not just have rules on trade in goods and trade in services, but also on sanitary and phytosanitary measures, technical barriers to trade, and intellectual property. You feel one of your partners is breaching the agreement, the state can go to dispute settlement. Dispute settlement is both binding, states are bound by the results, it's not voluntary, and states have to accept that mechanism. It's compulsory, unlike, for example, the International Court of Justice, where you have to agree for a case to go there. How does it work? The first step of WTO dispute settlement is consultation or mediation. So one party goes to another party and says, we think your measure, let's say they have raised a tariff, or they have a new labeling requirement that makes it really hard to export your goods, we think your measure violates WTO law. How does a country learn about that? Of course, it's the company that gets harmed that lobbies the state and says, oh, look, we have a problem here. Please, could you take that case to the WTO? Then the parties talk to each other. That's generally, there's a time limit for that of 2 months. And then party says, we haven't resolved it. We demand for a panel to be established. A panel is basically established ad hoc, consisting of 3 panelists, as a rule, who are picked from the trade community. Often trade lawyers, often people in the Geneva community. There's also a list, but the list doesn't necessarily mean that you will actually be appointed. That panel then has 8.5 months to come up with a report, and that report is adopted in a political body, but it's adopted by what is called negative consensus. So it will automatically be adopted unless everyone agrees it shouldn't, including the winning party, which you can imagine never happens. So the panel report will be adopted. And then there's the possibility of appeal. The appeal goes to what looks like a standing court with 7 standing judges. Currently, there's an Indian member of the appellate body, a US member, a Korean member, a Mexican member, a member from Mauritius, from Belgium and China. Usually the US and the EU always have a member there. And appeals can only be filed on the basis of legal error, so not on any basis of factual error. That usually takes 3 months. Of course, in very complex cases like Boeing, it might take a lot longer, but these are the guidelines for the time periods. And an appeal can uphold, modify, or reverse the ruling of the panel. Now, what is actually the outcome? Because now we're at the outcome of the normal litigation. What do these reports say? They will say, for example, the measure that you've undertaken, description of the measure, breaches WTO law, bring your law into compliance. So they're statements of where there is a breach of WTO law, and then the state has to bring its law into compliance. The state has 1 month to state its intention to do so. And then it has a reasonable period of time to actually bring its law into compliance. Now, what is a reasonable period of time? You can disagree about that. In fact, you can arbitrate on the term reasonable period of time. After implementation measures are taken, you might disagree whether the state is now fully in compliance. Again, that can be brought to dispute settlement with slightly tighter timeframes, but dispute settlement. And then you might still be in a situation where no implementation is done. So the state that has violated WTO law, and there has been a ruling that it has violated WTO law, but the state says, yes, I'm sorry, I won't do anything. So what happens in those cases? First, there will be a discussion about compensation. They say, you violated WTO law, we want at least compensation in some other field. Lower your car tariffs for your violation on beef tariffs. If that doesn't happen, you can ask for the possibility to retaliate, which is basically the WTO allowing you to retaliate in another field against the measure taken as an incentive to ultimately comply. Now, what does this mean in practice? Particularly if we compare the ECJ and the WTO. The ECJ, you have direct effect and supremacy. Nothing like that exists under public international law. It's, of course, each state that decides whether it exists, but for WTO law, all states have decided. There's no direct effect. There's no supremacy. There's no standing for individuals. There's no violation action filed by the Commission. Only states can complain about violations of WTO law. And whereas in national courts you can get a measure annulled, in the WTO, the only thing you can get ultimately, if a state still doesn't comply, is the possibility to retaliate. So what does that mean for, let's say, a Marmite producer? Let's say a British Marmite producer wants to export to Hungary, and you can now think of various measures. The Hungarian president, it's a hypo, there is no Hungarian president, they have a prime minister. The Hungarian president decides that a law has to be passed to make imports of Marmite incredibly difficult. You can think of various reasons. Either they say there are health problems. We pass a law banning Marmite, we think it's unhealthy. For justified reason, or because he's married to a Vegemite importer. You can also think of a more technical reason. Marmite is just reclassified from a tariff line that contains protein concentrates, which is the current tariff line, to jam, and the tariff rises from 2% to 5%. This, by the way, is the constellation of Van Rent and Loos, a case in EU law in which the concept of direct effect was decided. What do you do under EU law? You go to a Hungarian court. You say, Hungary is violating EU law. You can directly appeal to EU law, and the fact that Hungary has passed a law is irrelevant. EU law is supreme over national law. Case decided. What is the result? The Hungarian measure is quashed. You can import the Marmite to the tariff that was agreed on in the free trade agreement. What is the outcome in a WTO-like system? Well, first of all, you as a Marmite exporter have no remedy in Hungarian court because you cannot appeal to the trade agreement because there's no direct effect and there's no supremacy. So instead, you will lobby the British government. For a lot of producers, that's the end of the story because they cannot successfully lobby the government. Some systems have set up legal facilities to do the lobbying in a more legal manner. The US has Section 301, the EU has a regulation, China has a regulation, a lot of countries don't. Now let's say you successfully lobby the government. The government brings a case. That case will be the case of the government because only the state has standing in the WTO. You cannot do anything. If the government decides to settle, out of your control. Let's say the government wins the case, but Hungary still doesn't comply. Then what do you get? In the end, the UK may be able to, in retaliation, raise tariffs on cars imported from Hungary. What good does that do to the Marmite producer? Well, he doesn't care very much. And Hungary stays in violation, but there's retaliation. Now, the point of this is to point out that there is some thinking here to be done on what you want. Of course, the ECJ is intrusive of sovereignty. Direct effect, supremacy have precisely that effect, but it is to enforce an agreement. There's much more effective enforcement. If you let go of that, you have more sovereignty, but that sovereignty is also a sovereignty to violate an agreement. I'm not suggesting, and in fact, there is no optimal solution. There's just choices to be made, and the choice is not entirely clear and preordained. Thank you.
Thank you very much, Holger.